Well, good evening, everyone. I'd like to begin by acknowledging that we're meeting on the lands of the Wurundjeri peoples of the Kulin Nation, whose lands are unceded, and we pay our respect to elders past, present and emerging. My name's Margaret Young. I'm a professor here at the Melbourne Law School and director of our Institute for International Law and the Humanities, which is an institute aimed at building collaborations and understanding in a whole range of areas of international law, especially in interdisciplinary activities. So it's my really great pleasure to welcome Associate Professor Dan Joyce, who's visiting us from UNSW and who's expert in a range of international law issues and media law tech stuff. So he's bringing that expertise to us here at the Melbourne Law School tonight to speak about Meta's Oversight Board, giving us a critique that draws upon his knowledge and professional experience, especially within human rights. So with the format of the seminar, we are recording this. It will appear ultimately on the IILAH podcast. We'll record Dan's comments, which will run for about 40 minutes. And then I'm going to open up for Q&A for the remaining time. But at the moment, we're having both audio and visual recordings. So without further ado, over to you, Dan. Thanks.
Look, thank you so much. I'd like to echo Margaret's acknowledgement and also thank Margaret, the Institute and Melbourne Law School for this really great opportunity to present this work in progress. And thank you all for coming to engage with these ideas. So, as Margaret said, my research has focused on the interrelationship between media and international law, looking often at the absence of media law at the international level alongside the mediatisation of international legal forms and actors. To date, I've explored both regulatory questions and the critical potential of examining media's effects upon the international legal system. I also teach domestic media law, which has been quite helpful, I think, in terms of, because media law generally, I think it's fair to say, despite my efforts, hasn't really been considered very often from the international perspective, although obviously we're living through a time now where, because of the internet and digitalisation and these digital platforms, those regulatory questions are increasingly becoming at least transnational. So in both fields, I'm interested in the ways in which law understands a role for media and yet also acts in tension with the media as a competing system of authoritative knowledge and power. I'm interested here to begin to engage with the media theorist Cornelia Visman, and this is very early. I'm no Visman expert. I was inspired really to incorporate an aspect of her work in this presentation by a workshop that I attended in Helsinki with Panu Minkkinen and Matilda Arvidsson and others. And I know that Panu's been a recent visitor to IILAH as well, so maybe there's a nice kind of connection there. But the reason why I've found her work interesting is I think it offers a chance to think critically about the ways in which a traditional media law approach to the media may fail to account for some significant aspects of the digital transformation of media. Mediatisation, which I've tended to focus on in my work to date and in my monograph, can help in understanding these dynamics, but a greater focus on infrastructural and material questions is required, I think, to analyse communicative power in the context of social media platforms. In this paper, I'd like to re-examine some of the traditional conceptions of media within media law by considering media less as an expressive actor and more as an infrastructure. What do we lose and gain in terms of our critical legal understanding of the media when we think infrastructurally? How does such an approach shift our perception of media's power in the legal sphere? So, as I've said, this is an exploratory and early engagement with only one of her articles, Cornelia Visman's articles, Cultural Techniques and Sovereignty. I will first, though, examine Meta's Oversight Board as an example of both media and also media law in transition. I will then provide some critical reflections drawing upon Visman's approach. This will involve partly a rethinking of my initial and more traditional concerns about the limits of self-regulation involved in the Oversight Board's experiment, but also raises questions regarding the form of self-management offered by Meta in this experimental form of governance. So as we know, private actors like Meta have responded to criticism by developing new self-regulatory and private forms of media law and human rights. Traditionally, human rights critiques have focused on the role of public power, but increasingly there is concern with corporate power over international life, and obviously there's a wonderful laureate project here at Melbourne Law School led by Sundhya and with many others working on these questions. I think they're really, really fascinating, critical questions. Partly I'm interested here as well to think historically in other work that I've been doing around infrastructure. I'm interested to see the continuities that actually these private actors that we're concerned about in terms of Meta and the Oversight Board and the digital giants, those private actors were also quite influential in the earlier formation of communications infrastructure, thinking about telecommunications cables and so on. But that's another paper and another time. So I think it's true that the platforms, the social media platforms such as Meta, as it then was Facebook, were originally enabled by a techno-libertarian form of freedom of expression and international law's failure to capture economic dimensions, such as monopoly and taxation, in approaching questions of information governance. And now what we see is Meta responding to criticisms of its own human rights violations by developing this private form of platform self-governance, drawing on international human rights law, and I think with the potential to shape its future practices and significance. I argue here, and I guess this is the sort of more traditional critique, that such self-regulation remains inadequate and driven by reputational concerns rather than wider public policy considerations. So Tarleton Gillespie has written earlier of two dimensions of such governance, governance of and by platforms, but largely we've seen the latter, and the Oversight Board is an exemplary case. As Gillespie argues, both in terms of their impact on public discourse and for the lived experience of users, the rules these platforms impose themselves probably matter more than the legal restrictions under which they function. To understand the significance of Meta's Oversight Board, which can otherwise appear well-intentioned, innovative, experimental, and even progressive, it is helpful to view its genesis, I think, as involving a cooperative response to criticisms that Facebook wielded significant private power without public accountability. Indeed, from the beginning, companies such as Facebook actively resisted international regulation and disclaimed public forms of responsibility. Typically, social media platforms maintained that they were not publishers and hence should not be liable for the content they enable. But their significance in terms of information networks and transnational communications infrastructure, of course, began to capture regulatory and consumer attention, especially following the Cambridge Analytica scandal and their continuing connection to computational propaganda and other acts of violence. What was initially Facebook's Oversight Board, it has now been expanded, of course, to include other platforms under the Meta umbrella, such as Instagram and now Threads, promised an independent appeal process of Facebook's own content review decisions in light of corporate community standards and human rights frameworks. This influential model is, however, also shaped, I think, by corporate ideology and strategy, while clothed in the universalism of human rights and techniques such as proportionality and contextualism. The overt turn to human rights discourse in the decisions of what is now Meta's Oversight Board both globalises Facebook's earlier and inadequate approach to content moderation decisions, while simultaneously translating what had been critiqued as a parochial, one-size-fits-all First Amendment-centric approach to local contexts beyond the US, which increasingly represent the bulk of Meta's consumers. And I think that is a part of the story here in terms of the shift. So, for example, Siddharth Narain, who is at Adelaide and was at UNSW where I am before, has written really interesting work looking at how partly this move from a kind of First Amendment-centric emphasis on voice to thinking more about questions around safety is also a strategic choice around kind of a changing, market for Meta and consumer concerns. So encouraging civil society engagement on the ground and stakeholder input provides, of course, more nuanced context for decision making, but also offers benefits in that it brings long-standing critics of Meta inside the tent. The same can be said in terms of recruitment of Oversight Board members, who are notable for offering a more diverse and critical counterpoint to Meta's previously US-centric corporate hierarchy. Maybe we can't include Nick Clegg in that, but otherwise that was part of the kind of broader critique, right? That was a joke. Thank you for laughing. Perhaps conscious of this, the highly qualified and diverse group of members, which include critical scholars, digital rights activists, the former Guardian editor Alan Rusbridger, a Nobel Prize winner, Tawakkol Karman, a former Danish Prime Minister, and even a former judge of the European Court of Human Rights, have established an early record of overturning Meta's initial content moderation decisions. They have also come increasingly to ground their decision-making in the terms and framework of human rights. But I think here, one of the things that I'm beginning to understand, and I haven't done an intensive study, I'm more interested in the form, I guess, of the Oversight Board and how it's publicly presented rather than its kind of jurisprudence. Initially, I was quite interested in this question of what would happen if and when traditional courts started to follow, because I mean, we're already in media law teaching, the Trump decision is in the media law textbook. We're already teaching these cases as if they're part of media law and in a sense also a part of human rights law. And I was interested, well, has that happened? And it actually hasn't happened. I did meet a representative of Facebook when I was on sabbatical in London, and I asked, and she said to me with the sort of, kind of passion and commitment of a kind of human rights motivated employee, said, that's my dream. That is my dream, is for this body to start to influence decisions in this area. But actually, I think there's more interesting recent scholarship that's coming out, which has looked quite closely at the kinds of decision-making and the uses of human rights and really called into question whether actually that is the ambition of the Oversight Board. And obviously we need to think about Meta's broader ambitions. And there are really quite limited uses of human rights frameworks. Johannes, who's here with us as well, has pointed out in important work that there's very little engagement with regional African human rights jurisprudence, and there's very little detailed engagement with human rights jurisprudence. It's much more kind of, here's Article 19, here's kind of some generic interest in, the disciplines of proportionality, legality, necessity. Here's a little bit of context from the ICRC if they can help us with a commentary. Here's what the general comment number 34 on free speech says, but they're not really engaging with other court decisions. And so I've begun to kind of have to rethink, I guess, my focus there. And partly I'm wondering whether actually some of the infrastructural focus that I'm kind of interested in, it also explains what's happening. I mean, in a sense, maybe they have a kind of infrastructural authority that means that they don't really have to engage in the same ways as perhaps we would like them to engage. Anyway, that's a little bit of a kind of side path in terms of the paper, but I think it's just wanting to share with you the ways in which my own ideas have changed as I've been thinking through this. Okay, so there's obviously a great emerging literature here as well. So, and it's begun to kind of make some really important critical inroads into this experiment. So not only has Meta committed itself to the soft law framework for business and human rights, but in creating the Oversight Board, it seems to subvert the long-standing conceptual difficulties that human rights law has had in capturing the responsibilities of private actors as corporations. There will remain public avenues for redress, but surely, and I guess this is my concern, these may come to be a bit of a sideshow. Like if you really want to fix something on Facebook or Threads or Instagram, you're going to probably go to Meta, and it's or rather go to Meta, and through Meta end up with the Oversight Board. By modelling itself so closely, however, on at least in its sort of public communications on a transnational human rights court model, Meta's Oversight Board gives the appearance of universal application when, as Rishi Gulati, who's written an interesting piece on the board, has noted, in fact, its mandate is quite narrow. Its case docket highly selective, many people have critiqued that, and its policy and structural impact on Meta itself is questionable, or at least mixed. So Meta has to follow the decisions in terms of, removal up or down, but it doesn't have to follow the policy recommendations. And I think it's amazing how quickly, too, they're evolving. So when I first started delivering this kind of research, there was a specific number, and it said, there's 57 cases, and this is what they look like. Already, there are a large number of decisions, and they've introduced just this year an expedited form of decision-making too. So it's going to be quite hard, I think, going forward to track what Meta's doing, although their transparency sort of aesthetic will, I guess, help in a little bit in that regard. So the Slick and Dynamic Oversight Board website is interesting to have a look at, and it's a pitch-perfect exercise in inclusive, transparent corporate marketing, emphasising the global and diverse character of the board's membership along with their expertise and credentials. What it currently says is the following. The Oversight Board's mission is to improve how Meta treats people and communities around the world. We apply Facebook, Instagram and Threads content standards in a way that protects freedom of expression and other global human rights standards. And it's really interesting to see what the emphasis there is, because actually their own kind of standards really do come first. And that's borne out in terms of some of the decisions too. They're also much more likely to follow their own earlier decisions than they are to be citing other courts, as I've said. Okay. So the Oversight Board exists independently within a trust structure, so it does have some separation from Meta, although probably I'm guilty of bundling them together in my critique. And of course, it benefits from the resources and staffing that public institutions are increasingly starved of. Its constitutive document is its charter, and the current March 2024 model of the charter sets out the powers of the board in Article 2, titled Authority to Review, dealing with the scope, how people can take particular cases to Meta, or how Meta itself can refer matters, but then also the basis of their decision-making in Section 2. And for example, they state, for each decision, any prior board decisions will have precedential value and should be viewed as highly persuasive when the facts, applicable policies or other factors are substantially similar. When reviewing decisions, the board will pay particular attention to the impact of removing content in light of human rights norms protecting free expression. So there is something there, I think, that we need to grapple with over time in terms of, is what's involved with this engagement with human rights? Like, what is human rights in this experiment? Is it law in the way that we might understand in a different setting, or is it there as a sort of, guardrail or guidance to be used when it's useful and in the interests of the Oversight Board and its own engagement with Meta? So there's, as I've said, some excellent and critical scholarship on the stakes involved with this corporate experiment in human rights adjudication. For example, Barry Sander, who's written some very interesting articles on this, has written persuasively of the need to shift from a marketised, what he calls a marketised model, and towards a structural conception of human rights law in the context of social media governance. But it's hard to see how the Oversight Board's focus on speech in the commodified platform context offers anything other than a marketised model. He also points to the other twinned human rights context that is left in the shadows by the Oversight Board's narrow focus, namely the question of data surveillance. And I think that's a really interesting point, because that's really was one of the main, we're told, one of the main motivations for needing the board, and yet it doesn't really address data surveillance. That's been a broader criticism too, there is, I guess, more engagement with the special procedures. David Kay, as a special rapporteur in relation to freedom of expression, obviously did amazing work to try to encourage Facebook and then Meta to engage with human rights. And so there is a dialogue that's happening there that isn't happening necessarily with the courts and with other treaty bodies. But it's been interesting that some of the other mandate holders of other human rights are saying, well, look, you actually need to deal with our areas as well. So there's a fairly narrow approach, and obviously the privacy context is very noticeable. Evelyn Dweck is another really fantastic scholar here, and she's consistently offered a critical analysis of this experiment, really, I guess, quite a familiar critical human rights approach here, or critical international approach, forcefully pointing to the limits of international human rights law in content moderation more generally, and arguing that the indeterminacy of human rights, quote, creates room for the co-option of international human rights law discourse by platforms rather than their being constrained by it. And I think this idea of international human rights law as a discourse, a sort of malleable set of values and guides is I think, a useful one. There's a great new article in the European Journal by Anna-Sophia Tiedica and Martin Furtman, and they've recently analysed the Oversight Board in terms of what they term its developing semantic authority. And they argue that we should move beyond questions. A lot of the initial literature is about, well, is it a court? And, I must confess I was also very interested in, how is it going to affect other courts? They're saying we've got to actually move beyond that and look to what it does, including who it perceives to be its audiences. Here, Meta, its consumers, and only certain, as I've said, and as they also say, human rights actors are key interlocutors. This approach is also useful as I think it also points to the infrastructural location of this developing form of governance and reveals that despite the impression that the Oversight Board is a new human rights court with the seeming potential to shape human rights jurisprudence, in fact, as I've been saying, what is emerging is a highly selective engagement with human rights law and its institutions. So more broadly then, the Oversight Board provides an example, I think, of private power's co-option of human rights and the subversion from a discourse of critique to one of deflection, performative risk management, and self-regulatory dialogue with consumers, civil society, and some, but not all, international organisations. This, of course, is packaged as innovation and experimental transnational governance. The Oversight Board allows Meta to, quote, share responsibility for its public relations problems with its critics while appearing to be responding to them in human rights language. Corporate capture of human rights techniques provides cover for, while perhaps also simultaneously further damaging, the inadequate public international framework for governance of harmful speech and misinformation that I've spent quite a bit of time in earlier work looking at. So commentators have initially lauded its success, efficiency, and its compliance with human rights standards. So I've been trying to refer to some of the more recent, I think more interesting literature. Obviously there are more cases to work with. I'm going to disappoint you because I haven't done an extensive trawl through the cases. It's not really what I've been doing here, but I think that work is being done and needs to be done. But the thing is, actually, yeah, it does seem to be, apart from its selective engagement, it does seem to be ticking the boxes that the business and human rights community hoped it might tick in terms of compliance with human rights standards. And I think it is noticeable and notable that the Oversight Board, until more recently, has most often been assessed not in political terms, but rather in the context of its institutional form and experimentation, its funding, its commitment to transparency, and its careful adoption of procedural and human rights legalism. And obviously, I don't want to underplay the role of transparency there too. I mean, I'm somewhat suspicious of the role that it can play for Meta in terms of sort of washing its reputation. But I do think it's important to see this experiment as offering differing factions within Meta and within different settings to kind of leverage different kinds of arguments for this. So, and so more transparency has enabled us to actually learn a lot more about how these decisions are made, some of the inadequacies, some of the potential benefits, and so on. But more broadly, it's interesting that it presents, even though I think if you look at it more closely, it's not actually very engaged with in a detailed way with human rights jurisprudence. It does present in human rights legalistic ways. And the most famous case, of course, involving President Trump and January 6 is an excellent illustration here. So the Oversight Board ruled that Facebook could remove Trump from its platform, but required that his ban not be for an indeterminate period of time. Social media governance then is welcome if it can restrain the enormous digital power of these internet giants, but at present, I feel its own limitations loom large. So what then can thinking, and I just better check my time here, but I'm okay actually, good. I've been skipping some sections. What then can thinking with Visman in this very sort of rudimentary way, sorry to Visman scholars out there, add to an analysis of this new form of media and the innovative media law framework which is evolving to govern it? So far, as I've said, I've offered a fairly traditional critique of the Oversight Board, almost an instinctive critique. It builds on some of the suspicions that I had about Facebook when I was writing my monograph. Facebook emerged as a sort of villain that everyone was happy to kind of pile in on. But then it's a bit difficult when they do what everyone was asking them to do, right? Where do you go? Where do you go with that? And so I don't have a sort of magic solution, but I do think that thinking a little bit, maybe also thinking in a slightly experimental, for me at least, way about media law theory of a very different nature. And Visman looks at media law not in the way that sort of common law media law theorists do, and looks at media. Maybe she doesn't even really look at media law, but she looks at media in quite a different way. Has for me helped kind of trigger some different ways of thinking about what's happening. So, so basically, her classic article, Cultural Techniques and Sovereignty, what does it offer then in terms of further reflection on the Oversight Board as a mode and form of experimental media law? So Visman approaches media and media theory, as I've said, in quite a different way than media or human rights lawyers have tended to do, myself included, by reorienting a traditional legal conception of agency as inhering in the subject and thinking more fully about the agency and role of objects. And I have an interest in that because I've been working with many here at Melbourne Law School and Jesse Homan and others on materiality and international law questions, and trying to kind of bring together in this work on infrastructure sort of the two areas of my interests. What does thinking about that offer? So Visman reflects, quote, the default position of media and things that set cultural techniques into motion contradict a legally sanctioned and thereby particularly widespread notion, namely the claim that only the subject can carry out actions and rule over things. This default position clearly aligns with traditional assumptions regarding how media and media law should operate and interrelate. Often it is the media who in self-interested fashion have acted to attempt to shape and develop the law through advocacy before the courts. The courts in turn are figured as key arbiters of decision-making and media legal outcomes. The contours of media law tend to be focused through the lens of media freedom, less so in Australia, unfortunately, with my media law, media freedom hat on, with individual subjects positioned as key actors and representatives of more organised and institutional forms of media, both public and private. This has led to media law focusing on speech and journalistic content, with infrastructural and political economy questions left to differing regulatory paradigms, such as competition or telecommunications law. Social media platforms, as I've explored above, have begun to offer up their own developing forms of self-regulation, influenced by international human rights law and internal corporate codes. The operation of Meta's Oversight Board is a central example of this. But as we have seen, the Oversight Board offers a corporate replaying of traditional media law with its focus on communicative rights rather than regulating the medium. By encouraging thinking more specifically about the medium, perhaps Visman can help media lawyers to examine the converged interaction of the field's subjects and objects. By viewing media in more infrastructural terms and seeing the way in which the architecture of the platforms themselves is implicated in the communicative content under review, Visman's approach can both call into question some key traditional media law assumptions, while also underscoring, I guess, the key message I've been sort of hammering, that it's a rather hollow form of self-regulation that is offered at present by actors such as Meta. In her article, Visman writes of, quote, self-management or autopraxis of media and things, which determines the scope of the subject's field of action. At first glance, it might seem that the Oversight Board's evolving method of self-regulation is an innovative form of self-management. But the performance of governance offered is really more aligned with traditional forms of procedural and rights-based law than with any notion of autopraxis. As many have noted, by focusing so distinctly on questions of speech and offence, the narrative remains one of rights-based balancing of interests and contextual decision-making. Largely removed from view is the material role of the platform infrastructure. In addition, as Sandra and others have pointed out, the privacy violations which lie at the heart of the information capitalism model of the platform economy, although there's some people I think now who are saying, forget that, AI, we need to move on from that model with AI. I can't really expand on, I haven't caught up with that yet. And whose exposure initially placed pressure on the platforms to act, are not addressed by the content moderation framework adopted by the Oversight Board. The Oversight Board model offers Meta and its consumers a thin model of legal proceduralism which distracts from rather than draws attention, I think, to the deeper structural questions. Thinking about the role of media law as a cultural technique points to a different way of understanding the media and its relation to law. Visman refers to the analogy of the plough as an elementary cultural technique and reflects that the agricultural tool determines the political act and the operation itself produces the subject. If we work with the metaphor of the plough and think further about the platforms and their regulation in infrastructural terms, Visman suggests that we also need to pay greater regulatory attention to, quote, the given conditions of production, its material properties or spatial circumstances. The current framework of the Oversight Board could clearly do more in this regard, and Meta's media law making might be more effective and genuinely self-regulating if it were less focused on performing a subject-focused jurisprudence of rights and more attentive to the structural and material dimensions of its own rights violations. This would, of course, have implications for its own agency within the communicative field of action and may signal a further role for other public actors within this experimental form of lawmaking. Here it should be noted that the emergence of the EU's Digital Services Act and other state-driven forms of regulation may come to unsettle the self-regulatory authority currently enjoyed by the Meta Oversight Board. In Visman's metaphor of material and medium-focused agency, the bather is carried by the water, but Meta's media law experiment obscures the media's role and focuses again on the bather as a consumer who needs to be kept safe and to feel secure lest they drown in the swirling waters of offensive online speech. This is in fact a rather traditional move in media law, where the media often obscure their own power and culpability while advocating for subjective rights to media freedom grounded in a functional account of acting in the public interest. It appears that Meta is now playing a similar game. Alternatively, thinking with Visman about the Oversight Board as a cultural technique points to the possibility of a more radical approach to media law, less speech-centric and with attention to platforms as media. This will necessarily involve attention being given to the political economy and infrastructural power of private actors like Meta, who have worked hard to obscure such questions in their co-option of human rights discourse. Treating the media as an object and paying attention to the operational script underlying the procedural ritualism involved in the Oversight Board's framework points to a deeper understanding of where agency and power lie.
Well, thank you, Dan. Actually, you're right on time. So,
That's good.
Yeah, we wished you didn't skip those bits. But Dan, that was a really fascinating account and fits quite well with the themes of IILAH that you and I have been discussing earlier today. I was particularly intrigued to think of, I guess, the words of one of our favourite lecturers at Cambridge, Professor Philip Allott, who used to talk about the international society and how it, you know, we still didn't have an international law, ideal or real, that met the demands of an international society. And we do know the role that Meta and other platforms have in our social relations, both, I guess, within this room, but also through all of the communities that we inhabit. So that was a really, I think, evocative account that you gave that also reinforced, I think, the need for international lawyers to be aware of the domestic realm. I think giving your examples of the European Union and thinking through cases as they might appear in Australia, I think was really a valid point as well. I think when you were talking about the co-option of human rights, that's a familiar critique, as you say, and you were talking about freedom of assembly and the countervailing privacy issues, and I was thinking as a parent, children's rights is probably something that I guess the mandate holder for the rights of the child is probably at the door of the Meta board as well. And that also reinforced your observations about the structural and material aspects of these platforms, because one of my best forms of regulation is just to take that phone away. So yes, regardless of yes, exactly, the infrastructure has to be in another space, but I didn't want to be facetious about that point, but that does seem to sometimes work. So we do have time for questions, so please, who would like to go first?
I'm Jen. I'm a research fellow in the School of Population and Global Health, but I do corporate power stuff. I was going to say, your analysis of the co-optation very much resonated. I don't know if you do stuff with Gramsci, but it's very Gramscian, which it makes total sense. I was thinking though, like in other studies where we've looked at industries sort of responding to criticism and then co-opting the position of their critics with like hybrid cars or vapes in the tobacco industry or no alcohol soft drinks, alternative, whatever. One of the consequences has been sort of the fragmentation of that sector. So I was curious in your sort of conversation and research with the human rights space, if you're sort of saying like Facebook was the bad guy, do we now see the sort of deliberate and overt sort of splitting of the field and then sort of weakening there? That's question one.
Yeah, so thank you very much, Jen. So I do think it's been hard because in earlier work I've been very interested in the possibilities of technology. And I think obviously Facebook, despite all of its issues, or Meta, these technologies still offer tools for human rights actors, and I think there's a lot of, I mean, talking about Philip Allott, and I mean, I was quite influenced by him and his own form of sort of idealism, but sometimes doing something doesn't make things better, and I do worry about the turn to, and the ways in which, I guess, human rights has been turned to. And I do think that in terms of fragmentation, what's interesting is that no one's really followed, so perhaps it's understandable that Elon Musk hasn't followed this experiment, but that's another interesting question, is it going to provide a model for governance for other actors? I do think one of the things that I have been a little concerned about is, and you see this in our own domestic efforts to try to regulate misinformation and so on, that the multi-stakeholder approach, which seems very laudable, right? Because it's like, you know, getting all of these different people in the room and getting all of their, you know, ideas and trying to kind of engage and so on, that often actually it can end up with a fairly soft code that is really like some kind of corporate script and that then becomes the template for public intervention. I think it's different I mean, I'm no EU law expert, but I think what's happening in European Union context is different. Partly because I think they've got this humanistic kind of conception of the data subject and so on, and they're quite a distinctive approach. But I do worry, for example, that we tend, in the ways that we're currently developing media law in Australia, to say, okay, we really don't want to regulate you because of all of the very understandable anxieties about state control of media and information and so on. I don't need to rehearse those, so tell us how you'd like to be regulated, and we'll sort of introduce this as a sort of soft template, which we will potentially come in and do something about. And I kind of think there are so I do think that in terms of fragmentation, I think actually there are sort of similarities. And partly that's because for such a long time, there was such a pervasive idea that you shouldn't regulate technology, that you shouldn't. And I don't know if this is my own take on it, but it seems to me that I've done a little bit of work on internet freedom, and even quite conservative commentators like Jack Goldsmith have come around now and said, actually, we sort of stuffed it. The US, like really, in trying to kind of, I guess, boost Silicon Valley for geo-economic and political reasons, went with not regulating, went with trying to kind of build that as a sort of center for influence and power. But lack of regulation was part of that model, and now it's affecting. I mean, it's resulting in a sort of form of fragmentation. So maybe it's affecting domestic political systems. I do think. I mean, one of the cases that'll be interesting to follow in terms of the Oversight Board. There's a case that is pending about the Voice referendum as well. So it'll be really interesting. I think. I certainly don't want to underestimate the cases. They're really when you kind of look into them, they're quite fascinating. And sometimes, so for example, one of the ones I have looked at is this Armenian prisoners of war case, where basically they're trying to engage with the prohibitions on displaying prisoners of war under IHL. And the decision is, well, is there such newsworthiness here for kind of gathering human rights evidence? They're also worried about the loss of evidence. If you remove something, you can't prosecute it. You lose the chance for accountability and justice. So in some ways, they're disclaiming their public role, but then they're also really trying to engage with the basic methodologies of human rights investigations. So I do think that at a time when fact-finding is so tricky and complex, and information governance, I think, is a part of that. I think there are real issues. Anyway, hopefully that probably it's a very good question. I probably haven't got to it fully.
Hi, I'm Kirsty Gover. I'm a professor here at the law school and an old friend of Dan's, so I'm delighted to have him back for this talk. So I don't know anything about Meta, so my first question is, I guess, about the infrastructure you're describing. So some of what you have been talking about is sort of reminiscent of, I'm going to show my age here, those 90s debates about the World Bank and what the inspection panel would do and who was going to review the inspection panel and so on. And you will recall that the World Bank at that time was saying, no, human rights don't apply to us, but we will have this panel and we will write out extensively detailed policies, and the panel will review our performance relative to those policies. But those policies did not incorporate human rights. So I guess to break that question down, is the board the only conduit for international human rights, or is Meta also attempting to build those into its infrastructure? So that's one question. And the second question, which will also indicate how long it's been since I've thought about these issues in a detailed way, and you may have answered it actually in response to Jen's prompt. Do you remember these old sort of horizontal benchmarking certification schemes? So the apparel industry had one going for a while. It almost seems as though these corporations are not susceptible to that peer-to-peer kind of regulation. Is it out of the question in your mind? Is it something that could happen? Or are we just dealing with an entirely different behemoth now that's not susceptible to that sort of thing?
They're great questions. Thanks, Kirsty. It's nice to see you. Look, I think obviously some of these questions are quite old as well, and I'm relatively new to some of them in the sense that I have tended to look at media law I'm quite interested in media freedom in my media law scholarship. But yeah, some of the early kind of cyber law scholarship and IP scholarship, critical IP scholarship was very much making the point that, the architecture could have a governance sort of function. And obviously at NYU, there's a lot of interesting work on infrastructure as a sort of form of governance. One of the things that's interesting there is I think we need to think about, infrastructure is appealing to me, but I'm also starting to worry about whether I'm going to return to the problems I had with media as a term, where it can mean everything and anything as well, right? So it can be information, it can be the hardware, it can be the cables, it can be a lot of different things. Whether it provides some kind of node or some kind of point through which there can be a different form of governance, I think is in a networked context is kind of, I think, an open question. But I do think what's interesting is that companies like Meta, even the name, like this whole idea of the metaverse, it's quite absurd, really. And it seems that that's failed as a project, but they really do have this kind of, in terms of the social, they have this kind of alternative kind of conception that they could basically revive international society. It's not sort of Philip Allett's revolution of the minds, not of the streets. It's a revolution of, social engagement, updates or Facebook Marketplace or it's quite odd, or images or whatever. And so I do think they deeply believe in imagery, publicity, and transparency. Like, so much of it is about that. And I do think that they are trying to design so that they can incorporate these values. But one of the reasons why the Oversight Board exists is because it doesn't really work, right? So there's some really interesting scholarship where basically, a lot of the human teams that were initially working on content moderation, it's immensely harmful for their mental health, right? And then also for a long time, they just didn't have the kind of resourcing in terms of local expertise. Now what they tend to do, from what I can tell, and I'm engagement with Meta, a lot of scholars have, but I'm a bit sort of sus on taking their funds and meeting them. So it's a more of a kind of holistic kind of background kind of critique that I'm offering, which has some problems. But it does seem that from those who have looked at what they're doing in certain contexts like India, for example, that actually they have quite a genuine commitment to engaging local actors, and that in some ways, depends on what these different platforms mean in those settings, but in some ways, in Modi's India, it might actually, like Facebook's approach to what's happening might actually be a more kind of progressive and nuanced context-specific approach. And I think they're getting better at that. In terms of the design aspect, I just worry, maybe it's just the sort of traditionalist in me, I just worry about what human rights by design looks like. I think it's part of it, but I just worry that it's a bit like the conversations that we've tried to have at, my own university with computer scientists and so on. I know others here have had much more deeper engagements, but often the ways in which they're interested in the law are quite different, I guess. And so there is a kind of danger that there can be a sort of lost in translation kind of moment, despite the best efforts of people. I hope that partially answers.
Okay, next question.
Thanks, Dan. Yeah, it's super interesting. I have two questions. One is more directly related to the content of your presentation than the other. I suppose I'll start with the other. You kind of referenced at the beginning how potentially some of this emerged out of the sort of cyber libertarian propensity for self-regulation, et cetera, and hearing you have this discussion now about particular visions of the social and particular values being embedded in infrastructure. I was wondering, I read more and more now about the ideological orientation of Silicon Valley effectively becoming more conservative, more authoritarian, and what that means for, or how that might manifest or be expressed in sort of the infrastructuralization of oversight. For instance, like Elon Musk's takeover of Twitter and immediate dismissal of the trust and safety team, for instance, one thing. The second question, I suppose, is about pushing you a little bit on what might constitute the materiality or infrastructures that ought to be subject to this kind of oversight. Because as I understood your critique, you're suggesting that like here's this familiar critique of the oversight board. You're presenting another view, which is to say its inability or its failure to address some of these more infrastructural dimensions that have these other consequences that pertain to business model, that pertain to political economy, et cetera. And I'm wondering, what exactly do you mean? You know, and like I'm a Vismanite.
Yeah.
You know, that was my whole PhD. Yeah, I'm interested in what exactly you mean and how. And do you think it would be sensible to have an internal oversight board managing these things? And does that make sense in the context of the oversight board managing a particular issue that has to do with users' interactions with the platform and a specific set of community standards vis-a-vis how users are to engage, versus these other infrastructural things which are kind of more B2B, right? That users don't see, that are managed more or less by different kinds of contractual relationships. And does that not just become corporate governance to be like, yes, we should swallow up this other company. Yes, we should like do whatever we can to retain our dominance in ad tech ecosystems, et cetera. So I'm interested in where you think the sensitivities are that could be opened up by extending this kind of oversight.
Fantastic. Thanks so much, Jake. And I'm acutely aware that you're actually, you know, much more engaged with some of the kind of tech dimensions in your own work than I have been. But I think in terms of the first question, in terms of the ideological orientation, I think that's a really interesting point. I mean, it's interesting that, so I think, not that it really matters that much anymore, potentially, but given what's been going on, but Trump's back on Facebook, right? So they're almost, I mean, there is a sense in which I guess I am more broadly interested in the sense in which actually, bottom line, these actors have their own interests and they will operate with those interests primarily. Part of that interest is to appeal to their consumers, though, because of the criticism, because these places became quite nasty, people have left. I mean, I'm still on X, but it's not a very fun place to be anymore. It was quite an interesting place to be during the pandemic and quite a useful place for academics, for example, I think. But I'm seriously thinking about leaving it, although who will care? No one will care. I will care, so maybe I won't leave. I do think, so I read this book by Alice Marwick quite early on, which has influenced me, where she looked at, it's called Status Update, and she looked at kind of the sort of ideological values that were kind of embedded both in the, like in that whole tech bro culture. And so I do think actually, even at that earlier time, the sort of, it was more in the 2.0 participatory sort of heady days, actually, I think they were quite conservative then too. So I don't know that things have changed as much as we would like to think. And probably the same is true of Meta as well. And I think your point about Musk's takeover, I think really it's a very useful illustration of what can happen when, and this goes to Kirsty's question too, like obviously there are human rights teams and so on, and these people are doing really significant, important work, and there are these internal struggles that are happening. And then there's the sort of, you know, the tech computational sort of backroom sort of stuff that I'm less, like I sort of, I guess, one of the reasons why I found Visman quite interesting was because she's quite metaphorical, and in some ways she's pre-digital. She is pre-digital. right? So, but there's something about how she's sort of thinking about disrupting our sense of the material and how it acts on the subject that I found, I guess, helpful. And maybe I'm just making a kind of deeper point about sort of that Barry Sander is making too about, well, look, actually there needs to be more attention to the sort of structural questions. But I do think, I don't know, in terms of how one can govern it, is that a way of kind of thinking about that final question? Like what to do? Is it?
I don't know if I'm asking you to answer what to do.
Yeah.
I think it's more asking what's the limits of the
Yeah.
critique you're offering.
Yes.
Because, you know, we have these external rule systems
Yes.
as well. We have the Safety Commissioner,
Yes.
we have the ACCC, we have this,
Yes.
and these systems have their own
Yep.
issues, but they're effectively regulators managing the entity's business practices vis-a-vis other businesses sometimes, or vis-a-vis users in ways where the community standards are insufficient. And so, you know, you get like Twitter having a direct confrontation with the Safety Commissioner because it's not interested in this, or it appears less interested in what it would call like woke managerialism,
Yeah.
which I think this is.
This is, yeah, big time.
And is more interested in like, no, like we do what engineering
Yes.
allows us to do.
Yeah, exactly.
And so, yeah, I suppose I'm asking what's how far does this critique go? What does it
Yeah, look, I think you're right to point to its limits. I mean, in some ways, it feels a bit like it's a fairly tired critical human rights, critical international law critique. I guess one of the things, though, that over time I have been concerned with is just how, this is something that actually James Crawford said to me years ago during the PhD when I was first thinking about international law and media. It was like, how did just the internet come not to be regulated by international law? And I think there's so many good reasons for that. But I worry that so much of that conversation or debate was dominated by this really parochial, often US-focused conversation. You know, pick up any book about how we should govern. I did today, there's this new book about guardrails and AI and so on that looks interesting. I'll probably buy it, but it was all like US cases, and it's these sort of, the chapters flow like, and then there was this case, and it's sort of as if the whole kind of impact of what these platforms have done is beyond kind of regulation, and that we just have to let the private actors do it. And I do definitely think there are limits to what public actors can do, but I do think, I mean, I guess you have to be careful not to end up with a sort of murky pluralism, but I do think that we need to try to do some things. So, but I'm interested in different ways of experimenting with governance that might allow for a sort of more public model. And I do think that's coming, and perhaps it's in areas like competition law or taxation or, you know, I mean, I guess that's been the model in places like the EU and so on, thinking about consumer rights and so on. But I guess I have rather a nostalgic view of the public still and the social. And I worry about the fact that that the public interest is claimed by these private actors when actually I think, you know, the public, for all of its faults, could be doing more. Anyway, thank you.
Well, with that, Dan, we're going to close these proceedings. We're at time, but I want to thank you for the generosity with which you've engaged with these questions. And now I'm not worried that you ended a little bit early because we had this really great exchange. I want to thank the audience for coming out on a wet and wild Melbourne night. I hope you've gained a lot from hearing about Dan's work in progress, and we look forward, Dan, to seeing it when it becomes a publication, and we look forward to engaging with it further. I want to also thank Claire Rule and the team that has helped bring this event to you under the auspices of IILAH. And finally, let me thank Dan for giving us this really insightful set of ideas for this evening. Thank you.